Take it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. The sweet peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when sweet peas in the building, we be learning with pride. Minds on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Right to with the facts, pretty brown girl with the sass. Marildia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate. Take it to trial, where the truth gets loud and the laughs run wild. Sweet peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you write a line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made of gold. Hey! Take it to trial, from day to night and every wild mile. Sweet Pea's nearly strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial.
Hello, hello, hello. Welcome in, welcome in. If you are joining me and the crew from our LC coverage that we just had, guys, I truly, truly appreciate it. This is just like giving us insight to maybe why the judge is moving the way he moves. We do know that he had a reversal that came up last week on the 6th. So maybe that's why, because I'm pretty sure he knew his decision had been appealed, right? So we just gonna go take a glimpse of the case. Of course, they did not live stream this trial, which I don't know why they didn't. I bet you they'll live stream the next one. I bet you will see the next one. So I'm going to give you as much background information that I was able to find on it. Please make sure that you're hitting the like button as you come in. That way we can get to the beat of the rhythm of the night. So that way they'll know we out here and we are still streaming and making things happen over here at Take It to Trial. Let me see. Destinations. Okay. I must have missed that one. Okay, so let's do this. So let's start off here. They didn't. Yeah, I didn't think they did. I don't know. I mean, I kind of know why, but I don't know why. But let's go into. Our first thing I'm gonna do is I'm gonna show our new our. Let's see. No, that didn't work. To the beat of the rhythm of the night. We got courtrooms.
Take it to trial.
We don't want that again.
Take it to
Let me get our courtroom feed up, because this is where we want to be. Courtroom feed. This right here. Let's get rid of that. Okay, we got our courtroom feed. That's what we need. I was like, damn, my face big. Y'all know I'm just as crazy. Oh boy, let me take our Lindsay stuff down, because that is not what we're doing here. Right, we're not doing Lindsay right now. And I'm just gonna go to this report, guys. This is about children once again, so I just want everybody to know. So please guard your hearts. I don't think there's anything explicit in the stuff that we're gonna be talking about today, except for when they yeah, I don't think it's anything too, graphic, okay? Just so y'all know, but this does involve children. Wait a minute. I want to say the ages, wait a minute. I want to say they were 2 and 8, but don't quote me on that. Don't quote me on that. I'm gonna find out though. Okay, so let's start here.
Admitted to killing her 2 young sons as part of a ritual. There is now a small but growing memorial here for those 5 and 8-year-old boys.
It's horrible, it's heartbreaking, and it just brings me to tears, because to think of the terror.
2 bears, 1 for each child, killed in a crime even seasoned prosecutors cannot understand.
An innocent little boy who was stabbed 50 times is never, it's tough to get your arms around that one. It really is.
Family in tears packed the courtroom. Latarsha Sanders, seen only briefly, accused of stabbing her sons, 8-year-old La'Son and 5-year-old Edson Brito. Police believe they were killed sometime between Saturday afternoon and noon Monday. That's when Sanders asked for an ambulance for herself, apparently in a psychiatric break.
She reached out to a neighbor to try to get an ambulance for herself, not for her kids. And I think that says something right there.
That neighbor and first responders stumbling on the gruesome scene inside. Both boys on their beds covered in sheets. In police interviews, Sanders changed her story, tried to blame other relatives, then finally confessed to stabbing the boys with a kitchen knife. She'd been talking about rituals to her family for years. Relatives say she ranted about the Illuminati, and neighbors say she's into voodoo.
She explained the ritual, stated that it came out wrong with the first one and she had failed, and for that reason she had to move on to the second child.
There's no religion, there's no ritual, there's nothing in this world that should possess you to do that to your own children.
An autopsy is still being performed on the younger boys. State police have finished their investigation here. Sanders is currently being held without bail. She is back to court April 9th for a probable cause hearing. Live in Brockton, Sean Chiabat, WCVB News Center.
So as y'all can hear there, this is in Brockton, Massachusetts. This is like in probably the hood, the poverty area of Massachusetts. Probably, I don't know what the driving time from here to where Lindsay Clancy is at, in Duxbury, but of course you can see it's probably in an area that is low poverty, stricken. Her children were 5 and 8, as we just heard. They were stabbed very violently, y'all. And y'all can hear from the news report, she didn't even offer an ambulance for them. She called for an ambulance for herself. And the paramedics and everybody just kind of like stumbled in on this scene. But as you can see in the court records and different documents, that she had been talking about voodoo and rituals and all this stuff for a while. Even when she had her, what is it called? Her, when they went to go talk to her afterwards, it was the police interview, her interrogation video, all off, just off the wall. This became important because the defense wanted to use this as part of her psychosis and bring her medical records in. And for those that don't know much about the case, the Judge Sullivan, who is currently the judge that we are watching right now, this trial was up in front of him. So he handled this case when it happened, right? So he ruled out that her medical records could not come in and things like that. So let's go to our next video that we have here.
Details tonight in the murder of 2 young boys in Brockton. Police say their mother, who you just saw there, stabbed them dozens of times as part of a ritual. WBZ's Bill Shields is live in Brockton for us tonight with some of the shocking details that came out of court. Bill?
Dave, this is really unbelievable what happened on the 3rd floor of this apartment, and it's hard just to wrap your mind around it, that a mother could allegedly stab to death her 2 little boys.
50 stab wounds.
Anguished cries were heard in the courtroom when the prosecutor said 8-year-old Marlon Sanders had been stabbed 50 times. And his 5-year-old brother, he too was mutilated, allegedly by their mother during a ritual.
She explained the ritual and stated that it came out wrong with the first one and she had failed, and for that reason she had to move on to the second child.
It was yesterday when EMTs were called to the Brockton apartment. That call was made by the boy's mother, Latarsha Sanders. She wanted the ambulance for herself.
Sorry, guys, that's kind of repeating. I thought there was going to be something different on there, but that's kind of repeating what we already know. Okay, great. So this is
But
what
police then found the...
We're going to listen to portions of this this interview. Shout out to Say More. Say More is with the Boston Globe Opinion, guys. I want to, this is like, they did awesome work on, because the trial was not like televised, right? Which drives me like, crazy. The first thing that we're going to do, because I was like, well, could I go back and go see anything? But no, I can't. I can't go back and see anything. So, we are going to first go to the decision when she was convicted. And just so y'all are aware, she is appealing. So I am going to bring it up. So she was, it's so crazy, guys, because she was found guilty. I want to tell y'all, like, literally maybe a month before everything happened with Lindsay. It's so weird. Okay. So news released on December the 28th, 2022, because remember, they did not stream this trial live. A Brockton woman was sentenced today for brutally stabbing her 2 young sons. In Plymouth County District Attorney Timothy J. Cruz announced, right? So just so y'all aware, he is the same DA that is currently, that charged Lindsay. And I think this is part of the reason why they had to charge Lindsay, you know, especially with, you know, her Googling, her searches for, you know, sending Patrick out of the house. No reports in regards to this psychosis until afterwards, right? Latarsha Sanders, she was 48, was sentenced to serve 2 mandatory life terms without the possibility of parole in the deaths of Edson, Marlon, Brito, 8, and La'Son Brito, 5. Judge William Sullivan, y'all know that name, additionally sentenced Sanders to serve 9 to 10 years in state prison to run concurrent on a charge of witness intimidation. Now, I don't know. It says that she was intimidating some witnesses in there. Why, I don't know. Today's sentencing followed a 9-day trial, culminating in a guilty verdict from a jury yesterday. So she did have a jury trial. These 2 young boys were innocent babies with their lives ahead of them, DA Cruz said. This was an emotional and difficult case for all the family members involved. There were no winners in the courtroom today. This happened on February 5th, 2018 at approximately 12:07 p.m. Brockton police received a 911 call for a medical emergency at 247 Prospect Street. Brockton Fire and Emergency medical personnel responded, and they found Sanders outside the address, distraught and combative. EMS transported Sanders for medical evaluation, and Brockton police proceeded to secure Sanders' third-floor apartment. So she was already gone, according to what they're laying out in here. So she was already gone to the hospital. There they found the 2 boys wrapped in bedding. The children had each been, stabby multiple times and were determined to be deceased on the scene. Brockton police contacted state police detectives and assigned to the district attorney's office, and homicide investigations commenced. The office of the chief medical examiner determined the manner of deaths to be homicide and the cause of death to be multiple stab wounds. Investigators conducted multiple interviews with people associated with the victims. Sanders made statements to investigators that the killings were part of a ritualistic incident. Sanders cleaned up the children, placed them in their beds, and mopped up the crime scene. Sanders never sought medical attention for the boys. Massachusetts State Police located a kitchen knife left in the sink that was determined to be the murder weapon. The case was prosecuted by Assistant District Attorney Amanda Fowle and was investigated by the Massachusetts State Police detectives assigned to the Plymouth County District Attorney's Office and Brockton Police. Okay? So that's that little background that I have for you guys when they came out with their sentencing thing. I guess then they'll come out with something probably like that for LC. Okay? Now, this is the most important question that I've been trying to figure out throughout this, guys. Like, even when we talking about Lindsay Clancy, and they're going to start this off when we get to this one. Let me get it pulled up here. Once again, shout out to, because if not, I wouldn't have knew. And I'll put this in our CCG had told me about it, the opinion coming down. But I am going to, it's from the Boston Globe Opinion. It is called Say More. We're going to listen a little bit to this. And then they say, what is justice when a mentally ill person takes a life? And I think this is just like so important for us to try to figure out and wrap around. Like, what is justice? Like, when we even think about Lindsay Clancy, like, I guess there is no justice when we think about it. Like, I don't know. Because if the person is mentally not able to make those decisions and have made wrong decisions, like, are they really at fault for these things? Although, no, we don't want anybody to pass away or be unalive behind it, but what do you do with that? I guess it's my thing. So, let's listen into this. I won't play the whole thing. I will put it in our description box if you want to go and listen to it. It's not that long, and I think it's very, very, I think it's a good listen to. I think after I listened to this and heard and listened to I think this was the same day I listened to Lindsay Clancy's diary journal entries, and I came back the next day and was like, she's not guilty. she insane. I think this is also what pushed me to that. But let's listen in here, guys. I'm gonna put my headphones in so I can hear.
While listening. There was another similar story. In 2018, a mother in Brockton, Latarsha Sanders, killed her 2 young sons while having a psychotic episode. But the tragedy doesn't end there, says Globe columnist Yvonne Abraham. Yvonne recently wrote a 7-part series revisiting the Sanders case. It turns out Latarsha Sanders was prosecuted by Tim Cruz in Plymouth County. He's the same district attorney who is now charging Clancy in the Duxbury case. Yvonne followed the thread.
So I ended up writing a column about the Sanders case. I spoke to her attorney, and my conversations with him convinced me that there was a lot more there to look at. I was interested in how much attention the Clancy case had gotten and how little attention the Sanders case had gotten by comparisons when the two situations were so eerily similar.
So basically, Yvonne, I believe she's a reporter that she wrote an article after the Lindsay Clancy's case was getting so much attention. And she like, well, wait a minute, we had this case that back in 2018 that happened that didn't get no attention, but they are so similar. They are so the same. And so she decided to write an article on it, okay?
Latarsha, Black mother, living in Brockton. Meanwhile, Lindsay Clancy, white, a nurse, married to a tech executive, living in Duxbury, one of the wealthiest towns in Massachusetts. It seems like you were wondering, would the outcomes be different, right?
One of the things that I really was hoping to pursue when I reported these stories on Latarsha Sanders was to look at how inequality affects the totality of someone's life and not just what happens once they get into the courtroom. And so right from the...
So I think that's the one thing that she brings up in the beginning, like how, just because of where different people reside or stay, how things are not equal, far as how you are treated, if that makes sense. Let me see. Okay. I'm gonna let it play. Let me let it play. Okay. Because I'll be talking through the whole doggone thing. Hold on.
beginning, you could see in Latarsha Sanders' stories the fruits of that inequality. Her family was very suspicious of psychiatric help, and so they didn't seek it for her, but not just because they were suspicious of therapy, but also because they were worried that if they raised the alarm about Latarsha, that her children would be taken away by the state.
Mm-hmm.
Once she was arrested, they didn't know what to do. They didn't know that she needed a lawyer right away. They didn't know that she needed to be Mirandized, told of her rights in a way that made her consent with knowledge and her full will. The effects of those inequalities just kind of dominoed until she got into the courtroom, where it was easier for the prosecutor to argue that she wasn't mentally ill, but that she was evil.
So what I do want to put is, let me get in the part, because just so y'all know, they say Latarsha was some of the qualities that you hear people get up on the stand and speak in regards to Elsie is the same things that they are mentioning about her, that she was loving, she took care of her kids. I think she had one kid, because they both were boys, from our understanding, and the reporter, she'll get into it, where one of the kids she knew would probably be part of the LGBTQ community, that she embraced it. I think at different points in time he was, into like wearing pink stuff. So like, no matter what, she was like this mom of moms. Like, she had the bag with all the mommy stuff, like mom of mom. So it just kind of reminds me of so much of LC when people came and testified on her behalf in regards to she was like she was perfect. And then I'm like wondering, like, well, I've always been told that people can wear two faces. So like, you could be one way, out here in public, but then in another way you can be, totally different, like thinking different things. So just something to keep. But I think that she was kind of like that mom. But wait a minute, let me see. Okay, let me play right here.
Episode and what they did or didn't do.
Sure. I mean, I think it always had passed in the past. So a couple of years before she killed the boys, Latarsha started behaving more erratically and irrationally more regularly. And so she developed this obsession with the Illuminati, this idea that there was some secret cabal of people running the world. She saw conspiracies everywhere. She thought that the neighbors were listening in on her. She thought a friend of her daughter's was trying to poison the family. At one point, she showed up at her daughter Shalia's house and begged her to leave with her because she was absolutely certain that someone was trying to kill Shalia and she wanted to save her. All of these things are signs that we know in retrospect are the precursors to psychosis. But oftentimes, it's not even clear to a clinician that that's the case. And they're professionals. So if you're a family who's not used to dealing with mental illness, who doesn't know how to connect the dots, and more importantly, doesn't know what to do once you have connected those dots, it's impossible. And no matter how ill she was, Latarsha still managed to look after her children. She still got them to doctor's appointments. She still made their birthdays special. She carried around ultrasounds of her younger son, La'Son, in her bag. Like, she carried around 12 ultrasound pictures of this kid, for 5 years. She loved those children and she gave them a good life. She would take them to the park and have them chase the birds around. She would take immense pride in her cooking, and she carried around a giant bag, a handbag full of the business of motherhood, appointment cards for the doctors, artwork from her kids, math exercises, doctor's instructions, prescriptions, those ultrasounds. Like, anybody who has children knows that, that's all the stuff you need to carry around to do your job well. That's who she was.
I mean, one of the things that you did in the series, which
so there, so it's just seeing it, it sounds like a lot of the qualities that and things that we hear in regards to Lindsay's case. So I'm gonna skip a little further. I want y'all to hear, because of course I don't have the actual the actual interview, but here's a part of her interview when she was first arrested. I believe is going to go into here. So let me play that part so y'all can hear that.
So I think a really significant piece of the audio was the interrogation of Latarsha Sanders by the police at Brockton Police Station just a couple of hours after her son's bodies were discovered.
So we're just going to kind of walk through, again, what happened last night. And if you can kind of fill us in, and we have some more questions for you, kind of fill in the gaps until we kind of try to understand what happened and why.
In that interview, which stretched on for over an hour, you can hear her making very little sense.
When did you go there?
Today.
Today?
No, you didn't go there today.
No. You stabbed Marlon and La'Son last night, so you didn't go there with the babies.
Yes, said it was the ritual, the violent and the son.
It was very clear that she was not rational. She was very suggestible. She's simply not making any sense at all.
So even in her interview where she's not making sense about what's going on or what happened, instead of them, stopping the interview, knowing that, hey, this lady is not making sense, they continue on with the interview. Of course, she's in there kind of like, saying whatever, and they gonna use whatever. There was different points in times, at least what I heard in the interview from the clips that they spoke about, that it was kind of like like when she wanted to stop the interview, kind of like telling them that she wanted to stop the interview, but then they would continue on. So that just gives you a little insight in regards to it. I am going to put it's like a 25-minute thing that they do with the Boston Globe opinion. As I stated, it's called Say More. It is so it just, if you have a chance and you just want to hear it, it's just so much more to the case. So with her being convicted, the problem is that Judge Sullivan did not let any of her medical past history come in regards to her being possibly schizophrenic, her thinking that there's some Illuminati, that she was doing a ritual type of unaliving. And it just brings it back to the forefront because, I think that may be why Judge Sullivan is kind of like, trying to make sure he get this right. No matter what it is, the judge wants to make sure that they're going by doing what the law allows them to do. I don't think anybody's purposely out here trying to give anybody an unfair trial. I think that he wants to call balls and strikes. And it appears that whatever strike he did for this case, it was not correct. So what I am going to do is I am going to get up our actual arguments that they had in front of the Supreme Court in regards to this case, so we can kind of see
tonight.
them argue,
And the murder of,
which would be a good thing. I don't know about any of you guys, but I like listening to these or looking at these. I'm waiting for them to come with the little bell where they have to hit the bell when it's somebody else's turn. But let's get this up here.
Docket number S.
So we can see, and this is, you'll hear them say it, is docket number SJC 13552. For your entertainment purposes here. But just so sad. But, this, when I brought this case to your attention, I think that it's very important. Remember, she's in Duxbury. Elsie is in Duxbury. They got money. They have money. Latarsha was not in Duxbury. She was probably in, a very rough place, right? And, public defender. Thank goodness she had somebody that fought for her, continued to fight for her and her mental health and her stability, even after she was convicted and sentenced to 2 life sentences. And it's because her medical history didn't come in, I think. But here we go. Let's listen to the oral arguments that we have. Oral arguments. I don't know why I want to say something different than what it needs to be said, but here we go, guys.
JC 13552, Commonwealth versus.
See, that's what I do like. That's one thing that I noticed when I watched the Alex Murdoch or the oral arguments. I like that I seen a little timer, they only get 20 minutes. You get 20, you get 20, you get 20. And that's it. See, everybody get 20. And that's all I can give you. But let's listen in.
This is Latarsha Sanders.
Hey, Attorney Shaw.
Chief Justice Budd, and may it please the court. My name is Robert Shaw. I'm privileged to appear today on behalf of Latarsha Sanders, and I'm privileged to do so with her family, who is present today in support of her. The trial judge's wholesale exclusion of clinical evidence in the form of medical records and testimony about them was a clear error of law. Chappelle did not support it. Goddard did not support it. Defense counsel repeatedly sought introduction of medical records through 7 volumes of transcript, yet the judge prohibited that evidence from reaching the jury. Now, what the court is being asked to do by the government in this case is to rule in a manner that would undermine decades of law and literally flip it on its head.
Mr. Chair, can I ask you about the prejudice prong of your argument?
Sure.
As I read through the record, probably not as carefully as you, but as I try to look at the record on the procedural part of it that both you and the Commonwealth laid out on this issue, there seems to be at least some waffling by trial counsel as to the need for these records. I mean, there's a pretrial conference portion where he says, maybe all I'm looking for is what ultimately happened. And then there's one part of the transcript where maybe it's capitulation, but the defense attorney does say something like, well, what I can do is ask the doctor X, Y, and Z, did you rely on these records and the like? And that's on volume 6, pages 140 to 141.
So, Your Honor.
So, assuming, and I think it was preserved, that he asked and the records were excluded.
Sure.
But this more goes, in my mind, to the prejudice prong of your argument where the judge may have said, well, there were portions of the argument where the defense attorney said, what I'm really looking for is this, and that's what he got. So could you address that for me, please?
Yes. So to begin with, the language being relied upon by the government pre-trial is taking place pre-trial, and it was not intended to limit the evidence. And that is made apparent by his multiple subsequent requests through 7 volumes of transcript. It's made apparent by his opening statement. You can see from his opening statement, which is subsequent to that he believes the medical records are coming in. Now, I think you have to look at that language in context, because in context, what the judge is doing at that point is suggesting that, well, maybe you could reduce the volume of the number of medical records. There's no issue at that point about excluding the medical records. There's no indication that the defense expert is not going to be able to testify. And in fact, there's not even an objection at that point. And defense counsel's response is to say, I'm happy to refer to the medical records generally when discussing the expert's opinion. He's saying he's not going to refer to all of the medical records one by one. He's saying he'll do it generally. He's not saying that I'm not going to have his expert testify to the details of the medical records. He's not saying that he's not going to introduce them. So, at that point, there's not even an objection. And, was the language imprecise? Yes. But I think when you look at the record as a whole, it's clear he wanted the medical records in. Now,
and relate that to prejudice, please.
Yes. So the prejudice here is enormous, all right, because the sole issue in the case is criminal responsibility. These records supported severe mental illness. They were a critical foundation for the defense expert's independent conclusion that Ms. Sanders suffered from an underlying psychotic disorder. And this is just the same as it compelled the government's own expert to conclude that she suffered from paranoid schizophrenia and that she was highly likely symptomatic at the time that this occurred. So it's simply wrong that the jury never heard the evidence, and it would be fundamentally unfair to conclude that the government's post-conviction narrative about these records can substitute for a jury's informed judgment, or for the court to substitute its own judgment for that of a jury.
Well, that's what we do, though, when we review for prejudice, right? We do substitute our own judgment for what the jury would have believed had the particular evidence that was excluded. We do. That's part of our review?
Well, I guess it depends. I mean, here you can look at the volume, the immense amount of information that the jury didn't hear. I mean, at some point,
we are making that call, just to be clear.
right. But in other words, I just think that from case to case, you get past a certain threshold where it's just not appropriate for the court to act as a jury would and say, notwithstanding, this extensive evidence that's been excluded, we're going to find that we don't think it would have made a difference. Now, with respect to your question about defense counsel and his ability to make superficial reference to information, evidence that he wasn't able to introduce. No, I don't think that diminishes the prejudice. I mean, defense counsel was placed in a position of trying to salvage a defense that was essentially gutted by the trial judge's ruling, and he was relegated to making superficial reference to evidence that he couldn't introduce. And that's really not sufficient. It's a lot like saying to a defendant who wants to mount an alibi defense that, well, you can mount an alibi defense, but you can't tell the jury where the defendant was or who the defendant was with. And then the defense counsel tries to do his best with that by, in closing argument, simply referring to the fact that the government didn't dispute or present opposing evidence to counter, his bare naked assertion that there was an alibi. But, you really can't say that is not prejudicial. And there is an enormous amount of information in this record. That information is the essence, it's the heart of the defense in this case.
Can I ask you a question about that, please? So it seems to me that part of your argument is premised on a certain understanding about how Section 79 works. And I'm trying to make sure that I understand what your position is about Section 79. It seems to me you're arguing that because Section 79 makes the records admissible, they therefore would have been admitted in their entirety. And so when you refer to the sheer volume of information that didn't come in, that argument seems to me premised on this understanding of how Section 79 works. But that understanding of Section 79 seems to me to remove any discretionary function of the judge. So can you please tell me, first, is it your view that Section 79's making of the records admissible is the same as sort of automatic admission of them?
Well,
and if that's not your position, do you agree that there's a discretionary role for the judge? And then the third level to it is, assuming you would agree as to both of those, then what do we do with the fact that none of that happened here? In other words, how are we supposed to guess? Maybe there are things in here that genuinely, if the judge had taken a look, or if the judge, in other words, why is it that we're supposed to assume that it all should have come in?
Right. So, Your Honor, first off, the statute says that medical records shall be admissible.
They're admissible.
Yes,
right.
They are admissible. And the judge has a role.
There's a difference between, right.
I'm not asserting that the judge has no discretion, but the judge's discretion has to be guided by the statute. And the statute lays out fairly clearly, they shall be admissible. They're not hearsay. There isn't an authentication issue. They come in for their substance. There are certain limitations. If they do not concern medical treatment and history, then they don't come in. If there is a question directly to the issue of liability, then they don't come in. If, for example, there was some third-party hearsay that had no relationship to medical treatment, obviously the judge could exclude that. So there is a role there.
So then wouldn't it be more correct to frame your argument as saying that the parts that would have been admissible, Because you're just pointing to the entire mass of the record.
Well, Your Honor, I mean, defense counsel wanted the record in because his expert was going to testify about all of the information in this record, and he wasn't going to be cherry picking it. He raised this issue pre-trial. The Commonwealth didn't object until the 6th day. The judge didn't rule until the 7th day of trial. So defense counsel wanted to get this in. He had provided his slides weeks before the trial. So the government knew the areas that the defense expert was going to focus on, and yet no specific objection was raised. And it's the Commonwealth versus Francis in the statute itself. It is the government's obligation to raise a specific objection. Now, one of the things that happens in this case is that the government in their appeal is attempting to reframe the judge's ruling as based on relevance and probative prejudice analysis, assertions that are contradicted by the record. He rejected relevance entirely as a basis, and there was no prejudice probative analysis. And if you want to look at the sporadic discussion that occurred before the judge's ruling, and his ruling really made much of that discussion moot, but there was a lot of back and forth piecemeal discussion that the government hadn't even objected yet. His errors are numerous. He's misapplying Goddard and Chappelle. He's disregarding 233-79. He's equating medical diagnoses with testimonial hearsay from an NME or a DNA expert who isn't present to testify. He's improperly barring diagnoses, suggesting they're not admissible in medications. He's suggesting the need to produce the CVs of all of the treating physicians that are mentioned in the medical records. That's never been a requirement. And he's improperly placing the burden on defense counsel to call witnesses he had no intention or obligation to call. In the government's case, they then attempt again to sort of blame defense counsel for trying to salvage his defense. And as I indicated early, in essence, what the government is doing is they want the court to ignore the judge's error, and they want to focus on what defense counsel did or didn't do to ameliorate the prejudice of that error. And that was not his burden, and that was not his obligation. And we don't address judicial error by focusing on how defense counsel tried to compensate for prejudice caused by an improper judicial ruling. So on this issue, the judge's ruling was a significant error of law resulting in errors of judgment when weighing factors relevant to his decision. And we assert that the wholesale exclusion of medical evidence deprived Ms. Sanders of a meaningful opportunity to present a complete defense. Now, with respect to prosecutorial overreach.
And before you, I just want to, go ahead.
I had one more question too before you went to another. So one of the arguments you make about prejudice rests on the fact that the Commonwealth did not choose to call its own expert. Commonwealth was not under an obligation to call its own expert, correct? And what prevented defense counsel who knew of the Commonwealth's expert's opinion from bringing that person into court to...
Your Honor, nothing prevented defense counsel from doing that, but you know...
So how can all of these strategic choices then be the basis for a prejudice argument now?
Because, Your Honor, a couple of things on that. But first, with respect to defense counsel, he wanted to call the expert witness, but he didn't want to be boxed into asking direct examination questions. And for those of us who practice in the trial court, there is an enormous difference between being able to cross-examine somebody or really challenge them or preparing them and going through a direct examination.
Sure,
so he couldn't do that.
But then the Commonwealth is entitled not to call them.
I understand.
Right, so how does that all become prejudice?
Well, again, it just contributes to what happened here, because think about what the Commonwealth is requesting here in terms of interpreting the law. They want to render 23379 without force, so this stuff doesn't come in, despite the fact that it's admissible. And it would allow prosecutors to exclude medical evidence that is admissible but unfavorable to them by declining to call their own expert and not opening the door on cross-examination. So the prosecutor effectively limited this evidence from coming in, and the jury hearing it because of this judge's ruling. She was moving to exclude all of this in totality. She did not want the jury to hear this medical evidence or to have the defense expert testify about the basic foundation for his opinion and substantive evidence, observations, diagnoses, longitudinal evaluation of this woman. There are over nearly 600 references in those medical records to schizophrenia and schizophrenia-spectrum disorder. At
what point during the trial, in your view, did the judge's ruling regarding the medical records not coming in become, let's call it, final? In other words, it wasn't still under discussion.
Oh, well,
it
became final on the 7th day when he issued his written ruling. And his written, and you can...
And at that point, had the Commonwealth rested?
I don't believe. I'm not sure if.
See, if the decision not to call their expert preceded that moment, then I'm not sure how all of this argument really ties together. But
I guess I'm not following why. The judge did not allow the records to come in. He's not allowing the defense expert to testify about them. The government was not going to call their own expert because their expert found that she suffered from...
Sure, but I'm just trying to get at, if in terms of your argument about prejudice, and I don't want to belabor this point because your time is limited, and I know there are other questions.
And I had to follow up on the government's expert was Fiore, is that right?
Yes.
So, and there is some testimony about Fiore, and how did that get in, and what was it? Because I understand it closing...
There was no testimony about Fiore. There was information that defense counsel was reciting what she actually found when he was arguing that medical records should come in.
I'm just, in the closing, the defense counsel suggests they would have called Fiore, right? Right?
No, he was suggesting, he was trying to do his best with what he had, and he was suggesting that the treating physicians, that they would have called somebody from the medical records if the medical records would have helped them. I mean, that's what he's left with.
No, I'm not. I thought it was pretty effective, but I'm just trying to understand the basis of. I thought the defense counsel said the government didn't call its own expert.
Oh, I guess I'm not recalling specifically. They have said that, but
I'm
they didn't.
Trying to understand how he could have done that. There must be some evidence some evidence at trial that allowed him to do that. That's pretty good, right? That's the Commonwealth doesn't put on an expert, and somehow the defense counsel in closing is able to say, Commonwealth interviewed somebody and clearly came out the wrong way for them, right? I'm just trying to understand how they got into that.
Yeah, I think that he was just asking. All he had to deal with was what was not in the record. Okay. He had no affirmative evidence.
I am quite concerned about the law and order special victim stuff.
Okay. So, right. So if I could get into that very quickly, the central theme, the central lens through which the prosecution asked the jury to understand what occurred was that Miss Sanders is evil. The absolute reality is a simple explanation, the prosecutor says, and that is that she is evil.
I understand where the evil stuff comes from. I'm more concerned about that.
Well,
go ahead.
Right, and it's related to that with respect to the prosecutor mischaracterizing the notebook, jail calls, scene evidence, and interrogations of Miss Sanders. Yes, the prosecutor raises this law and order SVU issue.
Yes, at trial, she asked one of the police officers about the video that was on TV.
And the police officer couldn't say what it was.
And then she asked the officer, are you aware that there are 4 episodes of this where someone kills their kid and
Right.
brings up the voodoo stuff?
Right. So there
is there any basis in when she does that?
no basis whatsoever.
Is there an objection to that during the closing?
No, I don't believe there was an objection at the closing argument stage about mentioning the film, but there are really 3 errors that relate to the Law and Order SVU. Number 1, that it was on television at all. There's no basis in the evidence for that. That there was any particular show on, much less Law and Order SVU at the time the children were killed. There's absolutely no evidence of that. I mean, the crime scene video is being taken, maybe a day later, certainly hours and hours later. And then on cross-examination, the prosecutor suggests, without any basis in the evidence, that there are 4 episodes of Law and Order SVU where a mother kills her children and then claims voodoo. Now, that was entirely manufactured. There's absolutely no evidence of that.
And Dieters didn't agree to that, correct?
Well, I mean,
he says, I don't know.
He said he didn't see it. Yeah, she said, did you see that on the television? So she tried after.
A question is in evidence.
Right, she tried to elicit it from police officers. They said they didn't recognize Law and Order SVU. Then she said, did you see that on the television? He said, no, I didn't see it. And then she said, oh, so you're not aware of Law and Order SVU and, 4 episodes of mothers killing their children and claiming
And
voodoo.
does she bring that back up in closing?
Yes, she did. I mean, Law and Order SVU was part of this supposed motive, that she got the idea because, in closing
By the way,
argument.
there's nothing in our record to know whether this is true or not. Whether there are 4 episodes of this voodoo.
There's no evidence of it, and even if there's no evidence that Latarsha Sanders, assume there was, even though there isn't. There's no evidence that Latarsha Sanders saw them.
I take it the Commonwealth's going to come up and argue that she's weaving this voodoo stuff into what she tells the police officers of why, right? There's the voodoo. She brings up voodoo in her statement when she's being questioned by the police officers, right?
Yes, and I excerpted a lot of the statement, so there couldn't be any cherry picking, and you could see whether it made any sense.
The jury saw that whole. You give us 5 pages of, and the jury saw all of that interview.
They saw the interrogation. Yes.
On the issue of evil.
Yes.
It's mentioned by the defendant a few times. Is there a distinction between use of that term as far as a defendant's professed belief system or use of that term versus asking a jury for its moral condemnation of the defendant?
Well, I think the problem here is that what the prosecutor is saying to the jury is that she is evil. She, the person, is evil. You should disregard mental illness and.
So you're saying it's moral condemnation, not proper use.
Well,
could that term be used properly in a closing argument?
Not if it's focused on the person and it is.
What about the person's belief system?
I'm sorry?
What about the person's belief system?
Well, I mean, I don't think there's any evidence here about a belief system in the jail calls that are being cited, and this is part of the.
Well, it's an inexplicable crime, and then she at some point mentions, it could be the work of evil, correct?
No, she doesn't say that, Your Honor.
Give me the context then.
Yeah, so what the government is relying on are 2 jail calls that occur on a single day where she mentions the word evil.
She connects it to herself, right? Be specific.
Right, so
she doesn't. She says the evil in me or something like that.
No, she says she had the evil in me. During the jail call, she's actually suggesting that she was able to expel it from her body by urinating. So she's not saying I am inherently evil. She's saying I had the evil in me as she's trying to understand.
I haven't read the whole statements, but what I've read in the briefs doesn't have the urination point.
Well, my reply brief does, Your Honor.
Okay, but she says, again, this is in the light most favorable to them. She says, she uses this term in describing herself and having these evil episodes, right? Or, I mean, I'm not, I don't want to overstay. I just would like to be precise if we can.
Yeah, well, I'm trying to be precise, Your Honor. She uses the term, I had the evil in me this morning. I mean, it's a colloquial way of saying that she was having a bad morning, or let's say she's,
that's in the light most favorable.
Let's say she's referring to the fact that she had evil in her. Does that give the government then the right to have the equivalent of a Salem witch trial where in a murder?
They have the ability, the standard has a moral component to it, right? Can she separate right from wrong?
Your Honor, is the issue going to be, is Latarsha Sanders evil?
No, the issue is going to be, can she separate right from wrong? The proper standard we're applying, which is what is the right or wrong in the standard? What is the language we're interpreting?
It's both legal and moral.
Right.
The first prong of McCool has both a moral and a legal component to it, correct?
Yes.
And then the second prong is ability to
being able to tell
conduct.
right from wrong. But
right, in a moral and a legal sense, or a moral legal sense.
So how does that permit character attacks?
That's what the Commonwealth, that's what the prosecutor tries to do. Whether she does it fairly or not, that's, we can.
Yes, I mean, I don't.
She does say that the defendant understands the difference between good and evil. She even says it about herself, right? That's what the prosecutor does in closing.
Well, what she's doing in close is she's saying the absolute reality is a simple explanation for why this happened, and that is that she is evil. And this was
what page does that sentence appear that you just said? As I'm looking at the closing right now myself.
Unfortunately, I don't have it right.
It's important. Words matter.
It's cited in my brief.
I know. So, right. So my question is, can you point to a specific portion of the closing where the prosecutor went beyond the evidence in her use of the word evil?
Your Honor, evil is a metaphor.
Because there was evidence where the word came up. And so I think in closing, the question is, if she stayed within the bounds of the evidence, then it's harder to make your argument. So I'd like to know where specifically the prosecutor went beyond the evidence in her closing with respect to evil.
Well, I filed an opening brief and I filed a reply brief, which I think you both have. Those have all the citations to the record, but the bottom line is that there is no evidence from jail calls on a single day that Latarsha Sanders is evil, and somebody being evil is a metaphysical question that is non-justiciable, and it is not appropriate for a prosecutor to get up in front of a jury and, rather than looking at evidence and facts and then drawing reasoned inferences from that evidence and from those facts, to simply argue that the explanation for why this occurred is that Latarsha Sanders is evil. That is inappropriate. That is an improper character attack, because it is improper to say that the reason this happened arises out of the fact that that person is evil.
I do see that here. Looks like it's page 58.
I'd like to start with the closing argument issue raised by my brother. And
Actually, before you do that, can we just talk about the medical records?
Absolutely, Your Honor.
I just want to know if you agree that the judge abused his discretion in failing to allow any of the records in.
Not only did he not abuse his discretion, he knew exactly what he was doing, and he did it correctly. But in the end, the defendant got exactly what she was asking for.
Can you go through and explain how he did it correctly and not allowing any of the records?
Absolutely, Your Honor. So the very first pretrial conference, the defendant put forward that She wanted the medical records in because she wanted her expert to rely on them. That's all. He just wanted Dieters to testify that he reviewed a particular report and relied on it for his opinion.
Did you concede that the defense attorney moved for the records to be admitted into evidence?
Yes,
Okay.
at some point, because
Well, then it doesn't really matter what happened at pretrial conference. I know there's some wishy-washy part of the defense attorney's presentation, but there were two portions, as I read the record, where he said, I want these records in, and the judge said, no, you don't, correct?
Yes, that's true. I think he was kind of hedging and going back and saying, and he said it a couple of times, I really just want my expert to be able to say that I'm relying on these records. And he said no less than 4 times, look, I've subpoenaed the clinicians from Worcester that have.
If there were 2,000 pages of records that have references to psychosis and schizophrenia, how is that not prejudicial?
It is not prejudicial, Your Honor, and I've gone through, it's actually almost 3,000 pages of records. I've gone through them page by page, and I am confident that when this court reviews them, you will see on balance that they were actually more harmful to the defendant, because for at least 5 months after she murdered her children, there was no notation whatsoever, no observation, no clinician had a report on any kind of psychotic behavior. It wasn't until over a year and a half after this happened that there was any kind of diagnosis that included psychotic features.
The Commonwealth's position is that the defendant was not mentally ill, correct?
That she was not criminally responsible.
And not mentally ill. You said that, well, your prosecutor said that the reason she did this is because she was evil, not mental illness, correct?
Yes.
All right. Now we have 3,000 pages of medical records where we have diagnoses of mental illness, which bolsters what Dieters has to say.
I would respectfully disagree that they do not bolster what he has to say, because in fact they don't support at all. The whole crux of his testimony was that she was suffering from some kind of prefrontal lobe disorder or dysfunction. Nowhere in those 3,000 pages of records, when clinicians have been observing and evaluating this defendant over a period of about 2 years, did anyone ever mention a frontal lobe dysfunction? And this was the cornerstone of Dieters' testimony. So in fact, those 3,000 pages would have undermined his testimony. I think in the end, it would have been more harmful to the defendant. And particularly if you read the records, which I would submit are more relevant from MCI Framingham, which are closer in time to the incident. Throughout those records, there is no mention for months of any kind of psychotic behavior. And that's really what the jury is going to be looking at, is what is happening close in time to the incident. Yes, 19 months later, over a year and a half later, there are some diagnoses within there that incorporate some psychotic evaluations or psychotic diagnoses.
Do those relate back in time, describing this illness as something that's going to manifest, that it's not out of nowhere, right? Are there, I mean, I haven't read these 3,000 pages yet, not looking forward to it, but is it going to say that this type of mental illness is something that would have been around a long time, anything like that? Or is it going to just not try to trace it to cause? Because your own expert didn't testify and couldn't make a judgment call about whether there was a mental illness at the time, apparently. So that gives me some pause here.
Well, if I may, Your Honor, actually
the fact that you couldn't have anybody testify, it's like, interesting.
Because the actual evidence of what she did and said on and around the time of the incident was so powerful that we didn't need to.
I don't know. I've read the interrogation stuff. It's either she's a very good faker, which is possible,
right,
or that we're having some kind of really disconnected thinking here, right?
Well, if I could address both of those issues. As far as the interrogation, what is quite compelling about that is she immediately blames her son and the son's father for it. And she describes in detail what happened. And when the police are pushing her, well, why don't you have any injuries? Were you trying to stop what's happening? She immediately was able to turn around and say, well, they jumped on my back. And when they asked her...
Your brief sort of presents a coherent kind of, alibi defense. When you actually read the thing, it's incredibly incoherent. It may contain this in the light most favorable to you, but it's hard to follow.
Right, but at every point when the police were pushing her on, well, why didn't you use your phone? Well, my phone wasn't working. So she clearly was able to conform her conduct, to appreciate what she had done. If she wanted to, I suppose she could have said right away, I don't remember anything, or the TV told me to do it, Illuminati told me to do it. She could have said that right away, but instead she crafted this entire story about how someone else had done it, and she had tried to stop it, but she couldn't for all of these reasons. So she was clearly able to function and articulate a sort of excuse or alibi for her behavior. She understood what she had done. But back to your question, as far as I think you were asking me whether there was some sort of longstanding psychosis, I think that's what the Worcester clinicians were struggling with, because here she is in her mid-40s and all of a sudden this is materializing. And as your honors are familiar.
Do they struggle with that in those records?
They do.
Okay, but that's both helpful to you and helpful to him, isn't it too? Meaning, if they're struggling, there's a possibility that it was present, right?
And that's exactly what Dieters was able to testify. He was able to parse out the findings that supported his opinion. So in the end, the defendant got what she needed. She got the findings.
That's a prejudice argument, correct?
It is.
Okay.
It is.
Now, the first step is whether there was legal error.
Yes.
As I read Chappelle, it actually says the opposite of what the judge ruled. So how is there no, you're not conceding legal error, correct?
No, absolutely not.
Okay, then how are these records inadmissible?
So the way I read Chappelle, I think the judge did exactly what he, within his discretion, was supposed to do. So first he decides, I'm going to exclude these records. Some of them are not relevant. Some of them are misleading.
Chappelle, the defendant didn't wish to introduce the records.
Right.
They were admissible, and the court says, you should have introduced them. You didn't, so you're out of luck. This is the opposite of Chappelle.
Well, actually, the judge, when he decided I'm not admitting these for various reasons, he said, but you can rely on them because they would be independently admissible with the appropriate foundation, with the appropriate witnesses. That's exactly what the judge decided. Now, the judge had the
Independently
discretion.
admissible under Section 79.
And the difference with Chappelle is that the records, I believe, that defendant should have introduced were records that predated the charge. And so there could have been a presumptive reliability.
That goes to relevance.
Right.
Right. And this judge, as I read the record, says they are relevant. So that's out. You're out of luck on that one.
I think he was concerned with the reliability. You could see him struggling with.
Which is a confrontation clause issue, correct?
No, because the Commonwealth doesn't really have, unfortunately, the right of confrontation.
Correct. That's why there's a legal error here.
But it's the reason why the reliability is because the statute, going way back to Bushy versus Murray, that first case that really interpreted the statute, it's not a carte blanche to just, here's the 3,000 pages, go at it. And
we don't have a judge going through the records to say this part was admissible, this part wasn't admissible. He excluded them.
But the parts of the record that the defendant wanted to highlight in those slides was specifically the Worcester recovery evaluations. And that's really what the defendant
Where is it that where in the record does the judge go through those records and make a thumbs up, thumbs down determination about what's admissible and what's inadmissible under 79 or 79E?
In that written pre-ruling or preliminary ruling, he does go through the slides.
Right. When he goes through the slides, he says it's not admissible unless you bring a witness in.
Right.
Would you agree that Rule 79 or 79E, I forget the rule for medical records, eliminates the requirement to bring a live witness into court? That's the whole basis of the statute.
You're absolutely right, Your Honor, but there is still, as Justice Wolahojian had suggested, there is still a room for discretion, and I would point this court to, I found very helpful, Commonwealth versus Waite, which I cited in my...
But the problem is that's not how this case was tried. The judge didn't say, I know under Bucci and the cases of liability and third-party hearsay and treatment versus not treatment, there's none of that analysis for these records here.
He may not have done it explicitly, but if you read how he is going, and this is over the course of 5 or 6 days, what his concerns were, they're exactly what was addressed in Waite and what was addressed most recently in Commonwealth versus Chisholm, when you're talking about the presumptive reliability of mental health records that predate the charge versus those.
Chisholm has to do with the mental health exception to hearsay rule. It has nothing to do with Rule 79.
There was a discussion.
Or Section 79.
There was a discussion.
I'm kind of familiar with Chisholm.
I know, Your Honor, and I found that case incredibly helpful in terms of talking about the presumptive reliability of mental health records that predate a homicide versus those that are after the homicide because of the motive to malinger or whatever. So
the motive to malinger and all that is our case law, Panadosi, CYS versus Juvenile, Hamey.
Yes.
Those cases all deal with statements made to the expert witness. Most recently in Rodriguez, where he said those records are unreliable because they're made for court, as opposed to treatment records, which we have here.
But there should be a distinction, number one, between treatment records that predate a homicide and ones that post-date a homicide. And right. I will add,
that would be relevance.
Right. And I would add...
And you're out of luck on the relevance determination.
I don't think I'm out of luck. First of all, Your Honors can affirm on any ground that you want to affirm on, Your Honor. But I don't think I'm out of luck because it was something that the Commonwealth brought up, especially with the later records from Worcester.
Okay, on page 137, volume 6, the trial judge addresses relevance. And he says, let's assume that a doctor says these are relevant, which is Dieter's. If there's no other objection, I would allow those in. He finds that they're relevant. And then he looks at other objections and he gets into the stuff about Goddard in the basis of expert witness testimony.
But you could still find that they're not relevant, and certainly the ones that are further away in time. But back to the point as far as looking at these records and seeing whether they have those characteristics of presumptive reliability that is envisioned by Section 79. I do think that the judge properly exercised his discretion in trying to figure out, I'm uncomfortable with these diagnoses. And by the way, the defendant wanted to get in her court-ordered eval under Section 18A, which I believe under Rodriguez, if it were just by itself, would.
Well, that's different, though. A court-ordered evaluation is not a defense expert evaluation under Rodriguez. I've seen lots of cases tried where court-ordered evaluations do come into evidence.
But as it's not going.
But usually competency evaluations and the like.
But they shouldn't,
Section
for the reasons that were stated, basically.
Much different. A court-ordered evaluation is ordered by a court as opposed to a defense expert, which is not reliable under Rodriguez.
And she fully knows that she is in the legal system. She's aware of what is going on, that these things have legal implications. But beyond that, the judge is trying to make a discretionary call as to whether these records going to a jury are reliable or whether it would be better for a live witness to be cross-examined. So there are all these evaluations.
How does that? So I'm trying to actually figure out the Commonwealth's position as to, because now it's no longer clear to me, as to the basis upon which the judge actually excluded in toto medical records that were admissible by statute. Can you tell me what exactly is the Commonwealth's position as to the basis for the judge's ruling?
As I understand it and reading what he was struggling with, I believe that he found that some of the evaluations, some of the clinical diagnoses within the records should not be going in wholesale without a live witness. He was concerned about the reliability.
All right, so that seems to me that if that is the basis for the ruling, what undercuts that is the fact that the judge didn't then act consistently with it. He did not look at those specific parts that he's making, in your view, in the Commonwealth's view, I don't mean to personalize it, in the Commonwealth's view, reliability determination, and then excluding those. Instead, he's excluding the entirety of this woman's own medical history. And so that explanation doesn't, to be frank, really satisfy me.
Well,
in a case where it's the only issue, I mean, that's the other troubling factor, right? The only issue is whether she can.
Right, but keep in mind that all through this, the defense attorney is saying, I have subpoenaed the Worcester clinicians. They are going to be available to testify. If I don't get what I get out of Dieters, if I don't get what I need out of Dieters, I will have these witnesses available. Now, I'm not saying.
But doesn't that go to prejudice? See, this is why I keep going back to Justice Gaziano's first question, or maybe it wasn't the first question, but to actually deal with the first question we're going to have to ask before or answer before we even get to prejudice, which is whether there was error.
Right.
And that's the part that I really do want to give you a chance to give the Commonwealth's explanation for the global exclusion of otherwise admissible records.
So I think, honestly, the judge was focusing more on the slideshow and those pieces of the records that the expert was highlighting on the slideshow. So he didn't so much talk about the records, but I stand by my argument that he had the discretion under 79 to still decide which diagnoses had those characteristics of presumptive reliability. But beyond that, and this is what I'm struggling with, in the end, he let Dieters testify to all of those findings.
Before you go to the prejudice thing, because is the argument, and again, I'm having trouble following what the judge did, but is it basically that this is so enormous that what the defendant is trying to put in, the records are so enormous that if you just drop in this giant pile, it seems like it's the enormity of it is what's sort of leading him into to this categorical approach. It's so big that I'm going to exclude all of it until this gets refined. Is that
agree with you. I think that was the very first thing he said at the pretrial conference. Are we really going to give this entire pile of 3,000 pages to the jury without any kind of explanation or direction or anything? And that was absolutely his first concern. In the end, again, and going back to the prejudice argument, I've gone through the 3,000 pages. They do not help the defendant.
Can I shift you, because I know can I shift you to the law and order special victims thing that just seems really troublesome, that this thing not only comes in, but it also comes into the closing too. Why should I not be troubled by that?
Well, a couple
reasons. Error, right? It's clearly error, right?
Well, I first of all, the first thing I'll say is it didn't draw an objection, and sometimes things have less of an effect in person as they might on paper. But I will point out that in the defendant's interviews with the police, especially the second interview, and I believe it was around page 77, I don't have the record site, but I know it was around page 77 of the actual transcript, she talks about seeing something on TV as sort of prompting her to stab her children. And so obviously that now becomes an issue. What was on TV when the police arrived and found these children? And we have evidence.
How much later?
We don't actually know the timing. I'm assuming it was within about eight or 12 hours, but we don't know for sure. However, the way that these TVs were programmed, as you can see from the photos and from the crime scene video, it was queued up and playing something. So you could see that we don't know whether it was actually playing. I think you can make that inference, but it was queued up sort of to play.
I'm confused by that, meaning like this is, I mean, I queue up the news hour every day, meaning that because I was taping it, that means that I was watching it. I'm just trying to understand what the argument is.
It was something that the defendant brought up. That was the only objection, was that, well, we don't know whether it was playing at the time she actually decided to stab her children.
It was in her
and the judge said, well, you know, the Commonwealth can argue that inference. And those two programs were playing on the two TVs in there. So she was making an argument from the evidence. Now, it wasn't the centerpiece of her argument, and I would ask this court to, number one, not view that remark or these remarks in isolation, and number two, please look at the context of what the defense attorney argued. The defense attorney is essentially, his whole mantra is, well, she was a good mom, so she had to have been crazy, some general definition of crazy. And here's the prosecutor trying to kind of right the ship here. Now, hang on a second here. We have a very precise legal definition of criminal responsibility that we need to prove. Part of that is showing that this defendant had the wherewithal to appreciate the wrongfulness of her acts, to conform her conduct. So the prosecutor's taking the defendant's own words, own actions, and her word. She said the word evil to describe herself, I think 31.
I'm less bothered by the evil because I understand where that comes from. I'm more concerned about this suggestion about that this is a voodoo killing of children based on 4 episodes of Law and Order Special Victims Unit, when there's no evidence of that. There's no evidence she ever watched those 4 episodes. And the cop who's asked the question says, I don't think so. I mean, I don't know anything about that. So
well, I think it was Dieters
it's like the
that was
prosecutor came up with this herself.
Okay, well, I think it was, first of all, it was Dieters that was asked the question. I don't believe it was a police officer that
Dieters was asked the question?
I believe the prosecutor asked
I thought she
him.
asked a police officer. She asked one of the arresting officers, right?
Right, what was on the TV. I think it was up for the Stranger Things.
She didn't ask this special victims thing to the police officer?
I don't recall that specifically. Okay. I remember the Strangers thing, but I do remember her asking Dieters about the SVU episodes. Did you watch, and she did in the context of, did you even see the crime scene video, which Dieters did not. So that was the context of that question. And the defendant's own defense was all about, well, I'm following the Illuminati, I see these things on TV, I do them, you know, that is her whole defense. And so the prosecutor is trying to show the jury, well, you can have these kinds of belief systems, conspiracy theories and whatnot, but you still can't appreciate the wrongfulness.
The Santa Claus thing is out of line too, right?
I completely, no,
really?
I disagree.
I mean, the fact that we tell our children that we bring them presents on Christmas from a Santa Claus is somehow relevant to this? I mean, give me a break.
Well, Your Honor, I think what here, and again, we have to look in the context of what the defendant is trying to argue here. And the defendant's argument was all centered around this general sense of craziness. She had to have been crazy to be doing that. This prosecutor is trying to explain the legal standard here. And she is trying to convey that just because you have these conspiracy theories, it could be, of course, Santa Claus, because
Santa Claus conspiracy theory.
Well, it was Christmas time, Your Honor. And I also think that sometimes when you talk about conspiracy theories, you don't want to offend the jury because you never know who is going to subscribe to.
Believing in Santa Claus?
Well, that's pretty innocuous, but there are conspiracy theories that might offend someone. If you talk about, for example, the 2020 election or January 6th, people have different views on whether those were founded on the evidence. So the prosecutor's not going to use those kinds of examples that might be a little bit more incendiary. What she was trying to convey was that you can have a belief system, maybe even a belief system that's not based in evidence. However, you can still appreciate the wrongfulness of your actions and you can still conform your behavior. And that is what she's trying to convey. She is trying to lead the jury back to that legal standard and using the evidence of the defendant's words, her actions on and around the time of this incident, to show that she really was able to appreciate what she had done, what she was doing, despite having this kind of odd belief system. I just want to quickly return back to the issue of the records. I do want to kind of stress briefly.
Yeah, so yeah, we've talked about it, and if you've said it already, I think we've got a pretty good sense of where things stand.
Yeah, very disturbing. Prosecutors say that mother.
Okay, so I don't know why I cut off like that in the middle of her about to do her argument. That was weird. I thought that was going to be the whole thing, but it looked like it cut off. Let me check something real quick just to make sure. I knew it wasn't a long thing because, you know, they do 20-20. And it seemed like even though they give you your 20 minutes, you really don't get your 20 minutes because your 20 minutes is kind of 20 minutes with their 20 minutes. Like, okay. So let me just make sure.
People in Brockton come.
Yeah, very disturbing.
Yeah, I think this is the dad. Wait a minute.
27-year-old. Basically, for them now, 8-year-old, the mother.
I can't think of.
Problem with a psychiatric issue, with behavioral problems. Seek help for them now. 8-year-old Edson, Marlon.
As you, from what arguments we've heard and what y'all done seen, yeah, like I think that we have to let certain things come in to the case. So let me pull up the actual decision and what they decided, guys, because you know she is getting a new trial. I don't know how that looks. Like, they wouldn't come back and offer a plea deal, I'm assuming, right? Because remember, she got sentenced to 2 life sentences. So if they're saying that she needs to have a new trial, they don't do plea deals, right? I just want to make sure I got this together. Like, this wouldn't be a plea deal or anything. Right? Like, they can't come back with a plea deal. But anywho, okay. So it says right here in regards to the criminal responsibility, mental health evidence, medical record, hospital record, exculpatory, expert opinion, hearsay relevancy, and materiality, argument by the prosecutor, witness, expert, Patrice, criminal hearsay, argument by prosecutor, new trial, capital case. So they let you know it's going to be a new trial. It says in early February 2018, they do have the transcripts for this one too. I think I did see the transcripts. You know, the transcripts had to be ordered in order to file the appeal. But back again with the 2018, the defendant stabbed to death her two sons, 8-year-old and her 5-year-old. The victims were found in separate bedrooms, swaddled in sheets and blankets, had suffered multiple horrific knife wounds. There is no doubt that the defendant committed these incomprehensible crimes. The sole issue before the Superior Court jury was whether she lacked criminal responsibility. After trial, the jury did convict the defendant of 2 counts of redrum in the first degree on theories of deliberate, premeditation, and extreme atrocity or cruelty. On appeal, the defendant contends that the judge impeded her ability to present fully a criminal responsibility defense by excluding relevant medical records admissible under GLC 233 S79, documenting post-arrest diagnosis or treatment of mental illness. Now, I do know it took a long time for her to be competent to stand trial, if I'm not mistaken. The defendant argues also that several statements made during the prosecutor's closing argument were improper and prejudicial. Further, she requests that we exercise our extraordinary authority pursuant to the cite the code to order a new trial or reduce the verdicts. For the reasons that follow, we hold that the exclusion of the defendant's relevant medical records relating to the diagnosis or treatment of mental illness constituted prejudicial error, and as a result, the defendant is entitled to a new trial. So just based off of that fact alone, guys, like it didn't take much for them to do. It just says, for the reasons that follow, we hold that the exclusion of the defendant's relevant medical records that they argued in the pretrial motion relating to the diagnosis or her treatment of her mental illness constituted as prejudicial error. And as a result, they do a new trial just based off of that. We summarize the facts that the jury could have found, reserving certain details for later discussion. So they go back to so it says, oh, she had another daughter. So she had a daughter. The defendant's eldest daughter, Latarsha Sanders, also lived in Brockton with her children of her own. The victim's father, Edson Brito, did not live with the family. The defendant's mother, Arlene Sanders, lived in Randolph. In addition, the defendant had a 17-year-old son, Kadeem Sanders Alford. Oh, so she had kids, older kids, grown kids. Following the disagreement with his mother over household expenses, Kadeem moved out of the defendant's apartment to live with his girlfriend. Although she took away his key, the defendant told Kadeem that he could move back in at any time. Kadeem's father, I guess Alford, I don't know, lived in Fall River and was no longer close to the defendant. Prior to February of 2018, the defendant, by all accounts, was a loving, caring, and affectionate mother. She put all of her children first and had never been violent with Tamia, Kadeem, Marlon, or La'Son. So she had never had any violence or anything with any of her children. The defendant did not have a documented history of mental illness prior to the redrums, a fact emphasized by the Commonwealth. She had, however, become obsessed with a secret society called the Illuminati, fueling her interest by watching videos posted on the internet 24 hours a day. According to the defendant, the Illuminati ruled the world by sacrificing human beings and killed by the means of chemical bombs. The defendant was fearful that the Illuminati were out to get her and her children. Responding to this perceived threat on an unspecified date, the defendant rounded up her kids and fled to Connecticut. She also feared voodoo, a practice she associated with Kadeem's father. The defendant unalived her children sometime between February 3rd and 5th of 2018. On the Friday, February 2nd, the defendant and her 2 young sons spent the night with her mother, Earlene, in Randolph. On that Saturday morning, February 3rd, the defendant returned to her Brockton apartment with the boys to retrieve clothing and drove back to Earlene's house accompanied by Tamia. Later that day, the defendant brought Marlon and La'Son to a Taunton hospital due to concerns that they had contracted the flu. Despite plans to pick up Tamia at Earlene's house on Saturday, the defendant arrived on Monday morning, February 5th, by herself. By then, the defendant's appearance and behavior had changed. She told Tamia that she needed to protect Marlon and La'Son from their grandmother and her older sister, Shalea, because she feared that they would poison the children. Tamia observed that the defendant's clothes were disheveled, with one pants leg up, one down. The defendant's eyes appeared dark, her lips dry, and her breathing heavy and abnormal. She spoke in a mean and static voice, which Tamia characterized as very forensic. Of further concern, the defendant slapped her mother across the face, something Tamia had never witnessed. Wow, so she slapped her mama. Leaving her mother's house, the defendant drove her car, accompanied by Tamia, to Shalea's apartment. During the drive, the defendant explained to Tamia that they were going to have to beat Shalea up. Dang. Tamia, frightened by the defendant, sat in the back seat. Once there, Tamia ran from the car to warn her sister. The defendant lunged and hit Shalea, yelling at her mother to stop. Tamia was eventually able to break them up. Dang. So she went to go beat the oldest up. Gee whiz. The defendant then urged Tamia to come home with her because she was not going to do it alone. Tamia refused. On Monday, February 5th at 12:10 p.m., emergency medical technicians were dispatched to the defendant's apartment building for a suspected seizure. EMTs found the defendant seated on the porch, rocking back and forth under her blanket. After assessment, the EMTs placed her on a stretcher for transport to the Brockton Hospital with a chief complaint of behavior issues. The defendant began to scream, flare her arms, kick her legs, and throw herself back and forth. Asked what was wrong, the defendant responded that Akeem, the name heard by the EMT, and the father were trying to kill her. Police officers also responded to the apartment building, searched the defendant's home. They discovered La'Son's body tucked into a bed in the bedroom adjacent to the kitchen. He was motionless, cold, and stiff, with his eyes glazed over, indicating he had probably been deceased for quite some time. The 5-year-old was covered in blankets and a Spider-Man bathrobe with an elastic bandage wrapped tightly around his neck. Oh, wow. He suffered blunt force injuries to his face and back, along with a severe stab wound to his neck and his chest that penetrated his external jugular vein, cervical spinal cord, heart, lungs, diaphragm, and liver. Oh my goodness. Wow, guys. Yeah, I didn't expect that this was what the read was gonna be. You know, I did not read this, so I'm reading this stuff firsthand as we are looking at this. But oh my, good grief. In addition, there were post-mortem injuries consisting with over 80 superficial incised abdominal wounds and facial skin peeling, which was possibly caused by the rubbing of the corrosion chemicals, such as what kind of bleach? Oh my gosh, a candle was broken into 2 pieces and had been shoved down, oh my goodness, La'Son's throat, deep into his esophagus. What the fuck? Oh gosh, excuse my language. Oh my. Wow. Oh my gosh. On the floor of the another bedroom, officers located Marlon's lifeless body wrapped in several layers of bedding with his bare feet sticking out. He has suffered an overwhelming amount of sharp force injuries to his neck, transecting the carotid artery, jugular veins, trachea, and spinal cord. He also has stab wounds to the chest cavity and fractured ribs and punctured the hearts and the lungs. Like his younger brother, Marlon had been deceased for a little while. There was also evidence that the defendant had cleaned the apartment after unaliving Marlon and La'Son. Police officers noticed a strong odor of cleaning fluids on the entry and found bottles of ammonia and bleach on the kitchen table near a blood-stained mop and cardboard box filled with bloody bedding. In addition, there was a surprising absence of blood near the bodies, considering the number of extensive sharp force wounds inflicted on both victims. On further search of the apartment, officers discovered a large kitchen knife visibly bloodstained with Marlon's blood in the kitchen sink. The defendant's bedroom, officers flipped a mattress, revealing that the underside was bloodstained, again with Marlon's blood. Hidden up under the mattress were two more knives. One of the knives, trace amounts to La'Son's blood, were later detected. The bathroom sink, floor, and the bathroom were also stained with the victim's blood. Meanwhile, the defendant arrived at the hospital emergency department at 1:10 p.m. with signs of emotional distress, including moaning, yelling, expressing her fear of something or someone. Dr. Eric D., the attending physician, diagnosed the defendant with anxiety and stress reaction. He noted, "She does not appear to be psychotic. To calm her agitation, Deed administered a sedative, lorazepam." There we go with them doggone Pams, which reduced her wailing and her screaming. At 1:15 p.m., State Police Sergeant Sean Bello and Brockton Police Detective Ernie Bell interviewed the defendant at the hospital. In the 35-minute interview, the defendant claimed that her eldest son, Kadeem, and his father, Exter, had stabbed the victims. She insisted, I didn't participate in nothing. I was trying to stop it," responding to the police allegations. She posed the question, "Why would I hit the children? They're my children." The defendant detailed in a disjointed manner how Kadeem and Exner arrived. Exter, I don't know his name, arrived at the apartment at some point that weekend. Her baby daddy was armed with a knife, stabbed La'Son all over, and Kadeem stabbed his own brother, Marlon. She attempted to stop them by jumping on her baby daddy's back, but was hit on the back of her head with a frying pan. She left the apartment to inform the police, driving by the police station 4 times, but did not go inside or call because she was scared, as there were people following her. When she returned to the apartment, the doors were open. She found Marlon and La'Son in different bedrooms. The boys didn't get up. According to the defendant, her baby daddy killed them because he was angry with her for refusing to let him claim the victims as dependents on the tax return. I am done. She done made up a whole story. See, I don't know what this means. I don't know what this means. Like, she done made up a whole story, but she's supposed to be mentally ill, but I don't know what this means and how this works. Yeah, I'd have made him baby daddy because I don't know what his name is. Exner, I don't know. The baby daddy wanted to claim it on the taxes. I was just trying to see if there was anything I need to catch. Okay. The interview ended at 1:50 p.m. Dee did not see a need for additional medical workup or treatment. At 2:26 p.m., he discharged the defendant to the police custody because he had been assured that she would be in a safe place, unable to hurt herself or others, and that if released, she would return to the hospital for mental health evaluation. Thereafter, officers transported the defendant to the Brockton Police Department for an interview with Bello and Brockton Detective Santiago. In this 1 hour and 15-minute interview, which was audio visually recorded, the defendant continued to claim that her baby daddy and Kadeem went to her apartment uninvited, attempted to unalive her, and redrum the boys. According to the defendant, her baby daddy stated, "I'll show you something," and then he retrieved a knife and started stabbing Marlon. As this was happening, the defendant was being held down. She was told, "You're just going to watch. You're just going to watch this." She denied stabbing her children, insisting, "Nothing would make me want to do that." Again, she claimed that this was a fight with her baby daddy over the income tax. Questioned about Kadeem's motive, the defendant offered that he was always angry. Pressed by investigators to tell them what happened to those babies, the defendant responded, "All right, I'll tell you." She proceeded to provide the officers with multiple jumbled and incoherent versions of the events. Although difficult to follow, the defendant explained that the children were redrummed as part of a ritual. She stated that she did not know who stabbed Marlon, but the boy had to be done yesterday. The defendant attributed the killings to a couple of people on her Facebook social media page. The defendant claimed her baby daddy initiated the ritual. She denied participation, stating, "I wouldn't do that. I was there to watch. A short time later, defendant admitted that she stabbed Marlon because of the voodoo stuff. The defendant explained that she stabbed both of the children. Nobody was supposed to be getting hurt, as her baby daddy assured her that he just wanted a little blood from them. The ritual, she stated, is performed to get to the afterlife or achieve eternal life. Wow. The defendant did not understand that the ritual, but followed the instructions of bad people communicating to her through text messages. The ritual is somehow connected to the Illuminati, a group she described as the enlightened people. She learned through the videos that stabbing her children would make the Illuminati happy. The defendant stated that she only killed one baby, Marlon. He was stabbed in the legs and the chest with a kitchen knife. She admitted to stabbing La'Son in the chest because she fell with Marlon. Afterward, she bathed the children, gave them rice and ginger ale. What? Is she telling me that she unalived them and then she fed them? She gave them rice and ginger ale, wrapped them in a huge heating pad, and tried to fix them up to make sure they were still living. Oh my gosh, she thought that, oh my goodness. After the interviews, officers searched the defendant's vehicle and recovered a yellow notebook. In a notebook, the defendant listed goals including writing books, making money through an online crowdfunding page, and becoming famous. The defendant also wrote about Satan and evil, incorporating the word into the letter E in Edson and Marlon's name, and using phrases like evil son, evils living life large, and the devil's everywhere, run, save. Wow. This is wow. I wasn't expecting this to be in there, but Following her arrest and several recorded jailhouse telephone calls between the defendant and members of her family, the defendant expanded upon some of these ideas. For example, in March 2018, calls the defendant mentioned her plan to write a book and repeatedly described herself as evil. The defendant's case, at the trial in support of her defense that she lacked criminal responsibility, the defendant offered the expert testimony of Dr. Thomas Dieters, PhD, a clinical neuropsychologist affiliated with, oh my gosh, the McLean Hospital. Say it ain't so. It was told to us we cannot trust anything at the McLean's Hospital. Dieters evaluated the defendant to determine her psychiatric condition. The evaluation included 2 interviews, which were spaced 1 month apart and lasted a combined 9 hours, along with the 7 hours of the psychological testing and a review of thousands of pages of post-arrest mental health treatment records. The medical records were obtained principally from her incarceration at the Massachusetts Correctional Institution, and her commitment to pursuing, and then they, cite something to the Worcester Recovery Center and Hospital. Dieters also reviewed a report filed with the court by Dr. Stacy, a psychologist hired by the Commonwealth and not called to testify. So she was hired by the Commonwealth, but she didn't come testify. And I heard the reason why she didn't come testify is because she wasn't going to testify to what the Commonwealth needed her to. Dieter's opinion that the defendant was grossly psychotic at the time she killed her children, diagnosing her with schizophrenia-spectrum and other psychotic disorders. He explained that the psychosis can be idiopathic or unknown origin or caused by certain medical conditions, such as hyperthyroidism or vitamin D deficiency, both of which the defendant had. Make sure y'all out here getting y'all vitamin D. Dieters found evidence of psychosis from the defendant's notebook entries, the gruesome injuries she inflicted on Marlon and La'Son, and the bizarre conditions in which she left the bodies, including her insertion of a candle into La'Son's throat. He explained that the defendant's attempts to clean up the crime scene and deceive police officers did not change his opinion because the symptoms of her psychosis may wax and wane. Given the amount of time that the defendant was present inside her apartment over the weekend, she may have become more lucid, realized what she had done, and attempted to cover it up. In conclusion, he testified to a reasonable degree of professional certainty that, as a result of the mental disease, the defendant lacked substantial capacity to appreciate the criminality of her conduct and to conform her conduct to the requirements of the law. So that's basically what the Commonwealth have to prove, that Lindsay, she could appreciate this, right? Procedural history. On March 30th, 2018, the defendant was indicted on 2 counts of redrum, first degree, and violation. In December of 2020, the defendant filed notice of her intent to rely of her defense of lack of criminal responsibility. Following a 9-day trial in the Superior Court on December 27, 2022, the jury convicted the defendant of 2 counts of redrum in the first degree on theories of deliberate premeditation and extreme atrocity or cruelty. 1 on each count, the judge imposed concurrent mandatory sentences of life imprisonment without the possibility of parole. Thereafter, the defendant filed a timely notice of appeal. Discussion. The defendant raises 2 claims of legal error. First, she contends that the judge erred in excluding the entirety of her post-arrest medical records offered into evidence under Section 79. Second, she argues that the prosecutors Closing argument exceeded the bounds of proper argument by injecting prohibited personal opinions, inflaming the jury's emotion, and misstating the evidence. A, exclusion of the mental health records procedural history. At a pre-trial hearing that was held on December 1st, 2022, defense counsel indicated that they intended to introduce medical records obtained from the MCI and WRCH. He reasoned that because the defense expert Dieters would be referring to the content of those medical records, he should be permitted to introduce the records in case the jury wanted to look at them. The judge expressed concerns, our guy Sullivan, he expressed concerns about requiring a jury to shift through thousands of pages of medical records and asked counsel to figure out the best way to highlight important records. Defense counsel indicated that he would be perfectly happy as long as Dieters could say, I looked through the report of Dr. So-and-so from Framingham. That was part of the basis for my opinion. The judge allowed the prosecutor additional time to review the records and raise any objections. In its opening statement, defense counsel previewed portions of the MCI and the WRCH medical records. He emphasized that the records documented the defendant's episodes of psychosis and facilities attempted to stabilize her from insanity. On the fifth day of trial, counsel anticipating that the prosecutor might object to portions of Dieters' direct examination, referring to the contents of the defendant's medical records, raised the issue whether the medical records were admissible. At the time, defense counsel only referenced the WRCH records in his request. He stated, if the reports are marked as exhibits, it is part of the record, and therefore Dr. Dieters can testify in terms of what in those reports that affected his opinion. But later that day, defense counsel argued that Dieters should be permitted to refer to properly admitted records and evidence, and noted that he was not required to call the treating physicians to the witness stand. The judge provided the prosecutor with an opportunity to identify inadmissible portions of the medical records. The next day, the prosecutor filed a motion in limine, or lemonade as we like to call it sometimes, to limit Dieters' testimony to exclude irrelevant medical records documenting the defendant's post-arrest mental health history. The prosecutor argued the defendant's mental health status almost 2 years after the redrums is not appropriate or relevant based on mental health status at the time of the redrums. She also raised the hearsay objection. The judge held a hearing on the Commonwealth's motion in limine to limit the defense expert testimony. In the brief, the Commonwealth objected to the omission of the medical records for an irrelevant time frame and inadmissible hearsay in the form of statements by the defendant's mother contained within the medical records. Defense counsel moved to introduce the medical records that had been subpoenaed to the court from the MCI and also WRCH. He argued that Dieters would testify that those records were significant to him, informing him professional opinion, and that are highly admissible. Defense counsel insisted, I've got the right to introduce records that were properly subpoenaed by the clerk's office. The judge raised a concern about allowing an expert witness to testify on direct examination to potentially unreliable information contained in the medical records. While deferring a final ruling, the judge rejected the Commonwealth's argument that the medical records are too far removed from the time of the redrums to be relevant to the criminal responsibility. He ruled that, assuming that Dieters relied on the records to formulate an opinion, and if there was no other objection, he would allow the records into evidence. The next day, the judge denied the defendant's motion to omit the MCI and the WRCH psychiatric treatment records. In a written order, the judge addressed portions of Dieter's proposed a direct examination. He ruled that facts or data or opinions from the records may be elicited only by the Commonwealth on cross-examination, and where this door has been opened by the Commonwealth by the defendant on redirect. Okay, and so then they go into their analysis in regards to it. So the first step in their analysis is to determine whether the common law evidentiary rule limiting direct examination testimony of an expert witness precludes omission of the defendant's medical records, concluding that this rule of evidence does not bar omission of medical records. We address the Commonwealth's argument that the records in any event were not admissible under 79. Finally, we consider whether the defendant was prejudiced by an adverse ruling. So, limits on direct examination of expert witnesses. Expert witnesses may base their testimony on 1, facts personally observed, 2, evidence already in the record, or which the parties represent will be omitted during the course of the proceedings. Assumed to be true in the questions put to the expert witness, and 3, facts or data not in evidence if the facts or data are independently admissible and are permissible basis for an expert to consider in formulating an opinion. Okay, and then they cite it. Then we have the category. Let's see what else we got. Hold on 1 second, y'all. Hold on 1 second. I gotta go open the door. Open the door. Okay, I'm back. Sorry about that. Okay, so it's saying that here the judge ruled that the defendant's MCI and WHRC medical records were not admissible unless the prosecutor opened the door on cross-examination. Thus, he applied our common law evidentiary rule relating to facts and data not in evidence used by an expert witness to formulate an opinion. So this is talking about the judge, right? The underlying facts and data where none or one of the reports were offered into evidence. This was error. Defense counsel had moved to omit the medical records and evidence prior to Dieter's testimony. The judge at that point should have determined whether the medical records which had already been delivered to the clerk's office were admissible. So they cite the section that allows omission of substantive content of hospital records because of the presumption of reliability, which attaches to statements relating to treatment and medical history in these records. So, and then they cite some case effort information in regards to it. Let's see what else we got here. Medical records. On appeal, the Commonwealth argues that the defendant's medical records were not admissible under the section. Records kept up under the hospital shall be admissible as evidence in the courts of the Commonwealth so far as such records relate to the treatment of medical history such as, and then they cite in. So they say even where a proponent established these 4 criteria, a judge retains discretion to exclude portions of otherwise admissible medical records not relevant to the material issue of the case. So they're just saying that he was supposed to keep them in. So even though the Commonwealth contends that the judge properly exercised his discretion to exclude any portion or all of the records as irrelevant, any records as to which the probative value is substantially outweighed by the prejudicial impact, these claims are not supported by the trial record. The judge rejected the prosecutor's argument that the post-arrest medical records are too far removed from the redrums to be relevant to the defendant's state of mind. He ruled that the medical records, if relied on by Dieters to formulate an opinion, would be admissible. Moreover, the judge did not weigh the probative value of the evidence against the risk of unfair prejudice. So, of course, the Commonwealth is maintaining their position in regards to it. So, and they just kind of like going over the stuff that we just actually heard in the hearing, guys. So the closing argument, because the issue may arise in a retrial, we address 2 of the defendant's claims that the prosecutor exceeded the bounds of permissible closing argument. First, the defendant argues that the prosecutor committed profound and prejudicial misconduct by referring to her as evil. Wow. Throughout the closing argument. This perverse character attack, she maintains, was calculated to inflame the passion and prejudices of the jury. What y'all guys think about that? Do you think that they I guess they can't call them evil, right? Or monsters or anything like that would upset the jury? It is important to place the disputed portions of a closing argument in the context of the entire closing. So the jury instructions and the evidence introduced into trial. So they kind of saying, look, we're going to tell you some other things that you probably shouldn't do, but this is not the main reason why we're looking at this. The upsetting facts that, so yeah, maybe they shouldn't be doing that when they go for retrial, because they let you know the other stuff that you probably shouldn't do in the retrial if this come up. The prosecutor's use of the term evil premised on the defendant's own words written in her notebook and spoken in recorded telephone calls was permissible where related to the defendant's appreciation for the wrongfulness of her conduct. The judge instructed the jury that a person is not criminally responsible for her conduct if, as a result of the mental disease or defect, she lacks substantial capacity either to appreciate the criminality or the wrongfulness of her conduct or to conform her conduct to the requirements of the law. So that's going to be something that he's going to probably be given to Lindsay Clancy's jury. The prosecutor also argued that the defendant used certain episodes of a television program to concoct her story. Maybe there was something on that television that gave her the idea that helped her come up with the hallucinations and not the delusion, but the lies. Yikes. Okay, we recite the relevant trial testimony on February 5th at the an unspecified time during the day, the police officers entered the defendant's apartment and discovered Marlon and La'Son's bodies in separate rooms. By then, the boys had been deceased for quite some time, or a little while. At 8:30 p.m., the state police trooper videotaped the crime scene and captured glimpses of a SVU playing on a television in one of the bedrooms. Dieters, on cross-examination, admitted that he did not watch the crime scene videotape. The prosecutors then asked Dieters, "You didn't see the video that showed that on a television was Law and Order, SVU?" "No, I never saw that." That's his answer. Question, "Are you familiar with Law and Order?" Answer, "Not really. I mean, I've heard of it, certainly, but I don't think I've ever watched an episode of it." Question, "So you're not familiar with the fact that there are at least 4 episodes of women killing kids and claiming voodoo rituals in that?" Answer, "Absolutely no idea. It's the first time I've ever heard of that." The portion of the prosecutor's argument relating to the television program were impermissible. So no testimony or reasonable inferences drawn from that testimony established a connection between the television program that happened to be playing during the police investigation and the earlier murders, or whenever they were murdered. Like, there was no evidence to suggest that the defendant watched these episodes of the television program involving child murder or voodoo rituals or copied the plot lines. So, conclusion, for the foregoing reasons, the judgments are vacated, the verdicts are set aside, and the matter is remanded to the Superior Court for a new trial, so order. So there you have it. So she will get a new trial, but she's been in jail since 2018. I think she was convicted. I think the sentence, she was sentenced in 2022. So she's been behind bars for a very long time. I'm not sure if they even helping her with her mental health while she's behind bars, guys. I don't know what that even looks like, what her mental status is. I don't know if they give you the same treatment once you are convicted and you go to jail. It's to my understanding that the medical treatment is not the same as if you are in a mental health facility. So, she's definitely, going to get a new trial. We will be tracking to see. I'm pretty sure they are going to stream this trial, right? And this may give us a little insight into why our Judge Sullivan may be kind of like, he got a little pushback on and want to consider everything and take his time with things in this case. Because remember, this decision came down on August the 6th. So it just came down on Friday Thursday. I think Thursday. And trust me, yeah, he was a little snippy on Friday after, hearing about it coming down, but it's here now. So we shall see. But I just wanted to kind of go over that with you guys and show you the differences of 2 different courtrooms. So 2 different, coming from 2 different sides of the fence. And I don't know if she's insane or not, guys. I don't know if this really tells if Latarsha is couldn't appreciate what she was doing to the kids. I don't know that, and I don't know until we actually get into the case or they decide to show the case. But it's basically boiling down to she didn't get a fair trial and certain things were kept out that should have been kept out. That's why when I look at other cases that go up for appeal, like when we talk about a Zachary Adams, I'm like, okay, how does he not get an appeal? When there were certain things that were kept out of the trial that he didn't get, even if we take away his brother's testimony, Dylan, how does that not enough to start a new trial and, trial? But I think that a lot of people have different agendas. I almost think that this right here was put out here and a decision was made right in the middle of trial. I think everything is strategically done. Because I can't remember what day they actually heard this appeal. Let me see what day they actually heard the arguments. Because, I be thinking stuff be just, deliberately done. Like, they wanted to do this in the middle of his trial. Let me see. I pulled the form down. Like, yeah, we about to do this right in the middle of his trial right now. Like, we about to drop it like it's hot. Don't mess up nothing else, judge. Like, don't mess up nothing else. Don't you do it. Don't you mess up not another thing. So, so the decision was made on August the 6th. And yeah, I think they did it for a reason right then. But we'll see. We'll see how it goes. Can we get the link for Crime Club for Discord in order for us to be able to do our, for anybody that wants to go over to Crime Club? Are we watching Tupac trial tomorrow? They are picking the jury. Trial does not start for Tupac until Monday. Trial for Mario also won't start until Monday. So nothing will start for those trials on Monday. We will do some kind of case discussion. I'm never calling them a case prep or a deep dive because that's not what I'm doing over here. But I will talk to you and we can discuss some things and get some players in the game and know who we talking about when we talking about people when we get into the trial for the Tupac trial. So we will do some of that case prep, and I'm not sure. We won't do any tomorrow. Maybe we'll do some Friday, Saturday, Sunday, sometime over the weekend so we can get ready for Monday. We already together for our Mario trial, so we know all the players in the game there, and we'll get ready to know all the players in our Tupac trial. All right, guys. Well, I thank you guys for hanging out with me. Make sure you go sign up for Discord if you haven't. If you're on a replay crew, make sure you drop a note in the chat. I truly appreciate you. Shout out to all the new subscribers, all the people that were turned green today. Shout out to Susie. Shout out to Christian. Shout out to Marilda. Shout out to SD. Shout out to Drunky. SD monitoring the thing. But shout out to everybody who gifted memberships today. You truly are appreciated. That's what keeps things going on over here. So whether I say it or not, I really appreciate it. All the Jews and stuff. I don't know what these Jews do just yet. I haven't figured it out besides them looking cute in the chat. I don't know. I don't know. It's almost like they're trying to be like TikTok-ish, but I appreciate it. Even if it's lighting up the chat every now and again. I love hearing the noise. Like, I love hearing the noise, right? So I truly, truly appreciate it all. Thank you guys for hanging out with me. I am going to put our outro song on, guys, and I will see you in the morning at 6 a.m. Well, we'll start behind. I like us doing our TiVo time, so we'll start a little later than the rest, guys. Okay? All right.
Take it to trial.
I don't want to hear the intro. Do y'all?
When Sweet Pete's absent, you know the courtroom lights go bright. Trials running long, but the family's here every night. Mars on patrol, shadows showing out. This little YouTube corner's what community's about. Therapist you know, steady holding down the floor. Behind the scenes magician, keeping peace like never before. A banner king, a rule keeper too. Every channel dreams of a mind like you. Jason walks in and the ladies lose control. Down to earth king with the warmest soul. Film freaks, kindness, man, it's always on display. Fair and sweet and cheering folks along the way. And Marilia from SA keeps the laughter rolling free. Joking, shining, keeping spirits where they need to be. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This courtroom crew is everything we admire. Yeah, no matter what the case or file, we're forever taken to trial. Take it to trial. Pretty brown girl should tell you what's true. Sharp as a gavel, funniest in the room. Dr. Rachel pops in while she's busy running lines. Speaks her mind every time, cuts through like a knife. And Fowler brings the energy, jokes flying fast. Helping Sweet Pea backstage, making every stream last. Then Zach strolls and causing chaos just for fun. The resident cheater, but we love him, everyone. Here comes Maddie, handsome, quick with the line. A comedy sniper with the perfect timing and land with the updates. Always loyal, always tuned. If true crime news drops, he brings it to the room. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This coral crew is everything we admire. Yeah, no matter what the case or file, we're forever taken to trial. Take it to trial. Shamrock keeps us trending, replay queen, holding down the algorithm like a machine. SD's razor sharp, loyal through and through. And yeah, she adores chasing nothing new. Drunky the bear with the white claws, way managing volunteers like she runs the whole land. Cynthia brings inside what takes sharp and steady. Donna keeps it real, 911 and always ready till he burns the fat queen. Receipts on tap, Easy's new, but she blends right into the pack. Tennessee, hard live, try support her with pride. Melly shows up for family for cooking for his dog. A steady carrying presence through the courtroom fog. And Brooklyn in the house, always bringing that spark. Lighting up the chat like a shout in the dark. Baca loves her gram, speaks truth when it's time. Micrograms with metaphors straight up sublime. Barbara biggest supporter, heart kind of vast. Looking for missing kids, hope to truly last. Only fan from Singapore, flag name but sweet. Still shows up with love every time he takes a seat. And even the part-timers keep this place alive. Curvio, Irish Amy, Capri Law, Hellcat, our tribe. Hearts wide open, stories shared, holding space because we care. From every corner of the world we climb to spend these nights together, one trial at a time. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. Mods and shadows, yeah, this love is something rare. A courtroom crew with hearts beyond compare. No matter what the case or file, we're forever taken to trial. To Sweet Pea and the mods in the chat we adore. This isn't just a channel, it's a family. And we couldn't ask for more.
All right, guys, y'all have a wonderful one. Oh, you know what? I meant to say, thank you, Marilda. I don't know if I mentioned you in the gifted memberships, but you know, I know she was making it rain green on you hoes the other day. Y'all know I'm not calling nobody a hoe, like, unless you are a hoe. And if you are a hoe, you just be a proud hoe. But I like it to make it rain on them hoes, like they were making it rain on them. So it's nothing to be offensive or anything. I'm not like literally calling you a hoe. So please don't be in my dang on chat talking about in the replay like she be calling people hoes and stuff. No, I'm not calling you a hoe, but if it fits you, then let it be. But I like to say that make it rain on them hoes. Thank you so much, Martina, for your continued support, guys. All right. Don't do nothing that I wouldn't do. Have a good one, guys.